Thank you, Shirasab, and good afternoon to all. So this weekend we've been talking quite a bit about ADR and the interaction with courts here in Pakistan. And what I thought might be helpful is to talk a little bit about what the drivers of ADR are both here in this region and contrasting that with other regions. So if we take a look at regions such as North America, the US specifically, what tends to happen is you have a very large domestic litigation market that's very mature, which has courts that have subject matter expertise, and where the court systems have quite a bit of influence and leverage in that they can draw foreign parties into their court systems. What that then means is, from the standpoint of litigants, you have relative certainty with timescales, so parties have a sense of how long an action might take. There is some reliability or strong reliability in terms of the procedure. And there's a perception of fairness or reliability in terms of what the outcome could be. A result of that is that ADR is relegated to certain situations. So specifically, if we take arbitration in the US on the domestic front is typically reserved for either where one party has much more bargaining power or where the parties want confidentiality. And international arbitration is really there for cross-border situations. So if Samsung and Apple have a contractual arrangement and there's a fight, Samsung does not want to be hauled into American courts and Apple does not want to be in Korean courts. That's essentially what you have in a jurisdiction such as the US, and I think in England and certain other places. Here, the situation is very different. In Asia and MENA, there are very different drivers for ADR. So for instance, in Pakistan, some of the discussions that we've been listening to include concerns over timescales. So often cases which would take a certain amount of time in a different jurisdiction take quite a bit of time here, even though there certainly is subject matter expertise. We've heard from justices who have considerable experience and skill, but certainly there's at the very least, there's a perception concerning the timescales. And in my more limited experience, I can say that there are concerns of cases being trapped in amber and status quo remaining for quite some time. From a foreign investment standpoint, we've talked about some of the concerns, so those are obvious. And the short point is that, again, there's a perception concern that there would be a home court advantage or a foreign party would not want to come in for a fight here. And we can extrapolate some of those to other parts of the region. So if we look at MENA quickly, so in the GCC, one of the points that my colleague Omar mentioned was the distance between the language. So you have foreign investors that might have reliable courts to take their disputes to, but the courts are Arabic-speaking courts, and for certain foreign investors, they'd rather have a dispute be heard in English. And sometimes there's also concerns over subject matter expertise in some of the state courts, although that's improving. And the advent of the court that Omar represents in Qatar, what we have in the DIC and the ADGM also represent more optionality. But the point remains that in the broader Asia-MENA region, ADR has a much bigger place and bigger role to play. And that's quite important, I think, for all of us to understand. In the UAE, for instance, domestic arbitration is very common. This is I'm sure something that Robert can also speak on. So it's not uncommon at all in the way that it is in certain other parts of the world. And so then you have regimes where the international arbitration and the local domestic arbitration are quite similar in certain respects. And then certainly other parts of ADR, whether we're talking about mediation or we're talking about negotiation, expert evaluation, or DAB, those two have important roles to play. So just to conclude on this point, I think when we talk about the role that ADR has to play, the starting point again is what are the incentives that are driving these, and that can help us figure out the sort of shape we want these institutions to take. Thank you. So I'll speak briefly on the GCC regimes. What we've seen in the last few years is there's been a very positive, on the whole, relationship between the courts and the ADR institutions. So speaking of mediation, for instance, in the UAE, UAE has been quite clear about recognizing the role of mediation. As of 2021, there's been a helpful regulation in place which recognizes contractually provided for mediation. And then beyond that, the courts have also carved out certain cases that the judges are able to refer to mediation. Bahrain has had similar levels of progress. There's a 2022 decision which has been quite positive in that regard. And I think that's generally the case for the region. In the case of negotiation, that's also a mechanism that's frequently used. One point of caution for a lot of practitioners has been that traditionally across the GCC, the concept of without prejudice, or otherwise described as settlement discussions only, has not existed. And so parties that have been trying to negotiate an amicable resolution have been somewhat concerned about the types of points that they discuss in writing, or the quantum, for instance, that one party is willing to put forward. There are ways around it, or ways to at least mitigate the risk, but that's one point that I think still requires some improvement. And then on the arbitration side, in general, my impression is that the courts have been quite positive in recent years in terms of their interactions with the ADR institutions. This, I think, holds for the UAE, in my experience in Oman, in Qatar, and in Saudi as well. So, traditionally in Saudi, there were concerns that an arbitral award would be reviewed de novo by the courts, which rendered that whole procedure futile. But in recent years, there's been quite a bit of progress, and as probably many of us know, Saudi's made huge progress in the field of both domestic and international arbitration enforcement and recognition of the arbitration agreements. So I echo a lot of what Aisha has said. I think the way she's described Turkey is probably true of much of the region. I was going to say that the future for ADR across the region is very bright, but I realize that's a little self-serving. So let me just put it this way: it's here to stay. And what we see with institutions proliferating across the region, the existing institutions getting stronger, I think those are all reasons for us to keep an eye on what's going on. And what I mentioned earlier about the drivers for ADR, I think we need to keep those in mind. For those reasons, arbitration, mediation, negotiation, and some of the other forms, mechanisms, will be increasingly important across the region. There's a few things that I think there's disparate impact. So for instance, I mentioned the settlement discussions and the lack of protection in some jurisdictions. That's one to keep an eye out in terms of the GCC. Also, in some jurisdictions, nuisance litigation is disincentivized for the reason of costs. In other jurisdictions, that's not in place, but I think that too will shift over time. So let me just pause here, and thanks, Shiraz.